So for those reasons, which is what I'm trying to articulate, I do not believe you are entitled to yet another opportunity to attack collaterally the prior order, and the suspension and the now request to revoke it will proceed at this time. Now, I appreciate that Mr. Gwynn objects to that. His objection to that is noted. Now that we have completed the process of opening statements, we'll move to evidence. As I indicated earlier, Mr. Powers will present his evidence first, and then Mr. Gwynn will have an opportunity to present his evidence, at which time I will make a decision. Mr. Powers, you may call your first witness.
Your Honor, I will ask the court to recall the testimony of Ms. Warren, who's already testified when this case was recessed, that she's received no payments from Mr. Gwynn since January 2022.
I recall that testimony. You asked her one question. She answered it. That was the gist of the testimony, and then she was excused, and then you and Mr. Gwynn and I talked about reset dates and so forth. I recall it. What else?
I need to call myself as a witness on attorney's fees.
Raise your right hand. I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
State your name.
My name is William Powers. I'm an attorney licensed to practice law in the state of Texas. I've been licensed since 1976. I've been board certified in family law since 1988. I'm familiar with the fees charged in Central Texas by attorneys of
with you on that day. Subsequently, she
were $1,937. And since that time, we have incurred attorney's fees, the other hearings that the court has recited on the docket in the amount, total amount of $4,575.42.
Okay. And since July 6, 2022, you have incurred $4,575.42 in attorney's fees. Is that right?
Yes, ma'am. And those fees, have those fees been paid by your client? They have not.
All right, go ahead.
I believe those fees were necessary and reasonable given the circumstances of this case. It's been very difficult to get Mr. Gwynn in front of a court. It's been very difficult to proceed forward in this case, and we've had since that July hearing. I can't, and by the way, we're including today's hearing as part of that.
No, it's not.
Oh, I'm sorry, we're not including today's hearing as part of that. So there would be another $550 for today's hour before the court. And based upon the dockets that you previously read in, I think the court can understand just how much time has had to be devoted to get Mr. Gwynn before the court today.
Thank you.
And I'll pass myself.
Mr. Gwynn, now it's your opportunity to ask Mr. Powers any questions regarding the attorney fees that he's testified to this morning. You may proceed.
Your Honor, we all wish to remain in voluntary compliance with the IRS.
I'm sorry, do you have any questions for Mr. Powers regarding his attorney's fees request?
Yes, I'd like to know if we all remain in voluntary compliance with the IRS. Doesn't Mr. Powers?
I will object to the relevance of the question.
I don't understand the question, first of all, but I also don't know whether or not you or he are in compliance with the IRS is relevant to whether or not I should allow him or should award him, his client, attorney's fees for the work done on the case. So I'll sustain the relevance objection.
Because I'd like to know whose name goes on.
I'm just asking if you have any questions for him regarding the attorney's fees he's requesting today.
Whose name goes on the FinCEN 8300?
I don't know what that is either, and I don't know why it's related to whether or not he's going to get some attorney's fees. So if you have questions about whether or not he should be awarded some attorney's fees, you may ask him that question. I'm going to assume you don't want me to give him any attorney's fees, so I appreciate the position.
No, I don't. And
Okay.
Here's the Trezevant versus Tampa is billable at $3,000 per minute for renting my natural son, as well as time and commodity for total.
Okay. Mr. Gwynn?
My fees.
Mr. Gwynn? Mr. Gwynn?
Fees, and for
Mr.
renting,
Gwynn?
taking my son from me and
Mr.
making
Gwynn? Mr. Gwynn, can you hear me?
Yes, ma'am.
Okay. I'm going to ask you one more time. You will, let me tell you a couple of things first. One, you will be allowed to provide your own testimony when it's your turn. So if you want to tell me your side of the story, make whatever request you want to make. You may do that when it's your turn to testify. But right now, it's not your turn to testify. Right now, all we're doing in this very limited part of our proceeding is giving you the opportunity to ask Mr. Powers questions about his request for attorney's fees. That's it. And when we're done with that, we'll move on. But right now, we're just limiting your questions to his request for attorney's fees only, nothing else. So if you have a question about that, please ask that question.
Okay, I do have a question about that, because if he's wanting to bill me, is he gonna get my bill too? I have a bill as well.
If that is not a question about his attorney's fees, that's a question about your request. That's not what we're doing right now. So if you have a question about his request, what is your question?
The IRS handles issues of billing, and so I just want to know, do I put his name on the IRS documents that I submit for his billing?
That is not a question related to his request for attorney's fees. He wants me to order you to pay him. That's the only thing on the table right now. Do you have a question for him about that?
I do not consent to.
I appreciate that you want me not to give it to him. I get that. The question is, do you have any questions for him about it?
Ma'am, I just want to make sure we all remain in compliance with the IRS, and
I'm going to assume by your statement that you don't have a question for him about his attorney's fees. I, however, do. So I will ask it at this time, and then I'll give you a chance to follow up if you can think of a question. Mr. Powers, with regard to the order from Judge Harger awarding the $1,937, has that amount been paid?
No.
Okay. All right. And was there, excuse me. So, no, I just have some very specific and limited questions for both of you, and I would appreciate if you both just answer the specific questions I'm asking. Was there a date certain in the Harger order on which Mr. Gwynn was ordered to remit to you that $1,937 amount?
Yeah.
I believe so, Your Honor. We're going to pull up the order for the court. We'll ask you to take judicial notice of your court file.
I just want to know when he was ordered to pay, by what date he was ordered to pay it.
May the 6th, Your Honor.
Okay, I'm confused because I thought you told me it was through July 6th.
It was through April 6th.
I'm sorry. We've been so many hearings, I get a little confused. This was through April the 7th.
Not July.
Yes, ma'am. That's right.
So in April, Judge Harger ordered this $1,900 amount, roughly. Is that right?
May 6th. Yes, ma'am.
Okay, very good. That's my question. Now, I've asked a couple questions, Mr. Gwynn, so I'm going to give you one more opportunity to ask a relevant question about the issue of attorney's fees that Mr. Powers is requesting, if you have one, about that. And if you do, you may ask it now.
Your Honor, IRS handles those kinds of issues, but, earlier Mr. Powers said that there was a $6,000. If you note in the beginning of this hearing, he said there was a $6,000 fee that he had, and it's changing, and it constantly changes, and this is what Mr. Powers constantly has been burying me for years.
Okay, so that's not a question, it's a statement. You will be allowed to make statements both in closing argument and when it's your turn to testify. I simply want to know if you have a question.
Buckle up, guys. Today we are going to witness a courtroom hearing that quickly turns tense. Right from the start, the judge shuts down repeated interruptions and makes it clear that the case will move forward whether objections continue or not. As the evidence phase begins, the opposing attorney testifies about years of unpaid obligations and mounting legal fees. The stage is now set for a high-stakes decision that could dramatically impact Mr. Gwyn's future.
Yes,
Answer. What is the question you want to ask him about his request for attorney's fees as testified to this morning?
I definitely want a detail. I would like a accounting of it all.
Ask him a question, Mr. Gwyn. Take a step. Ask him a question.
I would like to request a detailed accounting of everything that he claims that I owe, and I would also like proof of this detailed accounting of what I owe, and I will take it under consideration. But I need to see proof. Where does he get these numbers from? Because they constantly grow, and it's like the $125,000 that he claims that I owe. Where's the proof of that? How do I owe that much, and why? Know why? So I'd like a detailed accounting, and I will take it under full consideration.
Do you have any other questions that you wish to ask Mr. Powers?
And my other question is, when will I get that?
Any other question you want to ask him?
If he can just answer that for us.
He's not required to give you what you've asked for today, and that is beyond the scope of what you're allowed to ask him questions about today with regard to the $125,000. I will construe your question about the accounting of his attorney's fees, and I will ask Mr. Powers to answer a question about whether or not he has detailed records with regard to the attorney's fees he's requesting today. Mr. Powers, what is your answer to that question?
And Your Honor, I accept that.
Hang on a minute. Let's let him answer that question first, and then you can ask another one. Mr. Powers?
Your Honor, I keep contemporaneous billing on a tenth by tenths of an hour, and so there is in fact detailed billing of that. I will show the court petitioner's number 23.
You have permission to share your screen.
And this breaks out for the court my billable time and the billable time of my paralegal. We will offer 23, and I will submit
Is 20, so let me just clarify, is 23 is your billable hour invoice records of your attorney's fees? Is that what you're telling me?
Yes, ma'am.
Is it an accurate reflection of the fees that you're requesting today and other fees listed in the exhibit?
Yes, ma'am.
Mr. Gwynn, do you have any objection to the admission into evidence of petitioner's exhibit number 23?
I would like to have it sent to me so I can consider it fully.
Yes, but do you have any objection to me looking at it, having it come into evidence?
Yes, I do, because you're not supposed to.
What is your legal objection to why I should not be able to look at his attorney's fees affidavit or request?
I don't know if you can practice law from the bench.
I don't intend to, and nor do I believe that's what I'm doing. I'm asking you to tell me what your legal objection is to the admission of this piece of evidence. What's your objection?
You can't.
Legal objection you have to it. Is it hearsay? Is it something else? That's
no, you can't. It hasn't been put under consideration, and you can't practice law from the bench.
Okay, I don't understand your answer to my question. My question to you. Let me summarize. Let me summarize. Mr. Powers is offering this document regarding his attorney's fees that you requested. He's offering that piece of evidence into this hearing as petitioner's exhibit number 23. My question to you is whether or not you have an objection to petitioner's exhibit number 3. And if you do, what is the nature of your legal objection to the introduction of this document?
Yes, I do, and I haven't seen it, and I need to see it and inspect it and then take it under full consideration. Once I do that,
okay, that objection overruled. Petitioner's exhibit number 23 is admitted. Do you have any other questions you wish to ask Mr. Powers?
I would like to name whose name do I put on the finance? And the
That is not a question, Mr. Gwynn. You've asked that several times. That is not a question about his request for attorney's fees. So if you have any questions for him about his request for attorney's fees, I will let you ask it. Otherwise, we will move on.
Yeah, I'll accept them after after I review them and then give full consideration on them.
Okay, that is not a question for him, so we will move on.
Petitioner's number 21, Your Honor.
Which is what?
Petitioner, I'm going to share it with the court. This is a that Mr. Gwynn sent to my portal for payment of $5,000 dated the October 18th is when it was the payment due, the payment date on this document. And
This is since the October 6th hearing in front of me, in advance of the October 21st hearing?
yes, ma'am.
Okay.
This is one of the reasons we kicked the case down the road. Was waiting for this to clear, and you'll see that it in fact did not clear.
All right, Mr. Gwynn, Mr. Powers has offered the transaction receipt for the payments that you indicated you were going to make, and he's offering this as evidence that those didn't clear the bank. You've indicated that they didn't clear the bank either, so I don't think they're in dispute, but I'll ask if you have any legal objection to the introduction of the documents. And if so, what is your legal objection?
Well, offer of payment is payment, and electronic fund transfer was successful. I checked with Telecheck, and it's confirmed. There's been no refunds.
Do you have a legal objection to the introduction of the document into evidence? You can dispute it if you want to when you testify. That's fine. But the question is there a legal reason why I shouldn't accept the document in evidence?
Yes, I would like to inspect it first.
All right. Well, he's showing it to us on the screen, and so that's what he's required to do. The
I need
I understand, Mr. Gwynn, I understand that you have objected to it. The objection is overruled and the document is admitted. Mr. Powers, is there any other evidence you wish to offer at this time? Petitioners 21 and petitioners 23 are admitted. Anything else?
Yes, if you want to.
I think I'm going to rest. I'm going to rest at this point, Your Honor.
All right, Mr. Gwynn, Mr. Powers has rested his case in chief. It's now your opportunity to put on your case in chief, and you may do that by offering documents into evidence, by calling witnesses. What is your pleasure with regard to how you wish to proceed next? You want to call a witness or offer some documents or call yourself as a witness?
The first thing I'd like to do is ask who gets my bill. Who gets the bill for renting my son?
So that is neither of the options that you have. That doesn't fall into any of those categories. So you can do a couple of things, right? You can call a witness. Do you have any other witnesses you wish to call?
I don't, but...
Okay, hold on. That's option one. Option two is that you might introduce some documents, very much like the process we just went through with Mr. Powers' 2 documents. Do you today have any documents you wish to offer into evidence today?
I do, ma'am, and I put them in evidence. I uploaded them into the...
Okay, well, tell me the number of the exhibit that you want to offer, and then we'll take a look at them, and then we'll see if there's any objection to them, and we'll proceed from there. And so what number exhibit did you upload that you want me to consider as evidence? And do you wish to testify about those documents, by the way?
I do, yes, ma'am, because I put
let me go ahead and swear you in. If you'll raise your right hand, I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay. All right, Mr. Gwynn, if you could just state your name for the record, please.
Jonathan Daniel Gwynn.
All right, Mr. Gwynn, tell me the exhibit numbers. If you could just briefly describe what those exhibits are. We'll go through those one at a time, please.
So, Your Honor, the first one is a filed and recorded promissory note. I'm not sure.
What's the exhibit number?
Ma'am, I do not know the exhibit number. I'd have to get off my...
Well, you said you uploaded them. Did you upload in some sort of order?
I uploaded So I have 3 documents that I want to submit. The first one is the promissory note. That's the last one that I submitted.
Okay, I'll tell you what, let's do this. Since there are only 3 of them, it won't be that complicated, and we can renumber them for you if we need to. Let's call the promissory note respondent's exhibit number 1, okay?
Okay.
And that'll be the promissory note. What is respondent's exhibit number 2? What's the second document?
It's a contempt of hearing notice.
The hearing then shifts to questions about attorney fees. From an observer's perspective, this is where frustration begins to build. Mr. Gwynn repeatedly argues that the amounts claimed against him keep changing and demands proof for every figure presented. The judge gives him several opportunities to ask direct questions, but the discussion repeatedly drifts away from the specific issue before the court, creating visible tension throughout the exchange.
It's exhibit number 2 is a contempt hearing notice, okay? And what's your third document?
One second, Your Honor. No, there's an allonge to the promissory note, but the other one is my Turner and Rogers request.
I don't know what you mean by Turner and Rogers request. So tell me.
An affidavit for
Hold on.
affidavit in support of sua sponte motion pursuant to 14.
Okay. That's.
I'm sorry, Mr. Gwynn, the last part of what you said cut out. You said affidavit in support of sua sponte motion pursuant to, and then I didn't hear what you said.
CFR 303.6. And then on my promissory note
Wait, hang on. Are there other documents other than those 3?
No, yes, ma'am, because on my promissory note.
Hold on. Is there another document that we could mark as respondent's exhibit number 4? And if so, what is the title of that document? If what you're telling me, if what you're telling me is that exhibit number 1 contains a lot of other things with it, that's all part of exhibit number 1 and will be considered all together. I'm asking, you told me you had 3 documents. We've marked those 1, 2, and 3. I'm just trying to figure out if there's a 4th one, or if you now want to stop talking about other documents and just tell me about the 3 that I'm trying to understand.
Okay, so the 3 on the promissory note, there's an allonge to the promissory note, Your Honor.
Is it part of what you uploaded into the box?
It is.
Exhibit number 1 with the promissory note?
Yes, it is.
I'm going to consider all of that number 1, and I'm going to consider the contempt hearing notice number 2, and I'm going to consider the affidavit in support of the sua sponte motion. I'm going to consider that number 3.
Okay.
All right. So, Mr. Powers, any objections to respondents exhibits 1, 2, or 3?
I wasn't, Your Honor. I also would like to submit tax forms 8300, tax forms.
Wait. I need to have exhibit numbers attached to these documents. So I need you to tell me the exhibit number. You told me you only had 3, and that's why I stopped.
Sorry, I have.
It's okay. What's number 4?
Tax form number 4 is my. I already gave you number 4.
No. Just tell me what the document is that you want marked as exhibit number 4. I do not have a number 4 yet.
80. Or the 8300 tax form.
Tax form 8300. Is that what it is? That we'll call respondents exhibit number 4.
Yes, and then number 5 is 4506A tax form, and number 6 is a W4, and number 7 is a 1099, and the number 8 is a 14309 tax form, and number 9 is a 3949A. I've already given you my allonge. And then a 1309.
Wait. Number 9 is a what?
3949A tax form.
Okay. And what's number 10?
13909 tax form.
Okay.
And then a 211.
Is that number 11?
11. And then the 12 is
Wait. What is 211? What is that?
tax form 211.
Okay.
And
All
then
right.
the tax form, and then the tax form 911.
Is that number 12?
Yes, ma'am.
Oh.
And I need a copy of their W-7
No. Your introduction of documents that you want considered in evidence.
Yes, ma'am. I'd like to offer their forms W7, W8, W9, and FR 2046.
I don't know what you mean when you say you want to offer their forms. Have you uploaded documents into the box folder as required by our rules? Documents that you want to offer in your box folder. Do you have those available today?
Yes, I do.
What is the number? Next number would be 13. What is number 13 that you want to offer?
I would like to offer W7. 14 is a W8. 15 is a W9. 16 is a F as in Frank R 2046.
Okay.
And
any other documents you want to offer today?
No, ma'am. That'll do it.
All right. Those are 16 documents. I might need a little more information about some of them. Tell me about the tax form 8300, which is marked as exhibit number that document, and why is it relevant to this proceeding?
I'm sorry, Your Honor, I wasn't done. I had one more, and it's called a 56F. I'm so sorry to do that to you.
No problem. 56F will be number 17. What is a tax form 8300, and why is it relevant to these proceedings?
FinCEN, and I have to report the money. It's a FinCEN. I have to report the money.
What does it have to do with whether or not you are in compliance with your child support obligation?
Because I have to be in compliance with the IRS, Your Honor. We all do. Okay.
All right. And is that the kind of the same nature of these documents, like say, for example, the numbers 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17 that you also said were tax forms? Are those related in some way to some obligation you have to the IRS?
Yes, Your Honor. And it's also identity theft for my Social Security number.
All right. Sorry, hang on. You answered my question when you said yes. Number 6, Respondent's Exhibit number 6, which is a W-4. Whose W-4 is that? Yours? I couldn't hear you.
There's, Your Honor.
W-4, Exhibit number 6, the W-4 form, that's, whose name is on the W-4?
Powers.
Okay. All right. I think I have a sense. Thank you. That's really helpful. Oh, another question about your exhibit number 2. What hearing notice, contempt hearing notice is that?
That is for Turner Rogers. No, that is let me get that. Let me pull that up.
You told me that number 1 was a promissory note. You told me number 2 is a contempt hearing notice. I want to know what hearing is related to that notice. Exhibit number 2.
Okay, so that is a judicial notice of Article 1, Section 10, Clause 1 of the United States Constitution, which states...
Wait, hang on. Stop. I'm asking if there is... You said it was a hearing notice. I'm simply asking what hearing date is mentioned in that notice and in what court? That's my question.
I've requested a hearing for it, Your Honor, but it's to because no state shall make anything but gold or silver coin a tender in payment of debts or law impairing the obligation of contracts. This state prosecutors...
Mr. Gwen, stop. Stop. Is the hearing notice that you marked as exhibit number 2 filed in this cause number in Travis County, Texas? Yes.
Ma'am, it is filed now for the 3rd time. I filed it.
My question is it a hearing notice in which there is a hearing scheduled in this cause number in Travis County, Texas? Does the notice tell you or Ms. Oren to be present at a hearing in Travis County, yes or no?
Absolutely, Your Honor. It's been stamped. And
all right, very good. And if it tells somebody to be at a court hearing in Travis County, can you tell me the date of that?
It was never set, Your Honor. And I put it in court now over 6 months ago.
All right. Okay.
And I have...
That's helpful. Stop. That's helpful. I'm just trying to get a sense of what hearing date it's a reference to. Thank you. All right, Mr. Powers. your opportunity now to tell me if you have any objection to any of the exhibits that have been offered. Let's start with the first three. Any objection to one?
Your Honor, one more thing is, all this is for the Foreign Agency Registration Act is what these documents are for.
Thank you, Mr. Gwynn. It's now Mr. Powers' opportunity to answer my question. Any objection to exhibit number one?
Yes, ma'am. Relevance.
What objection do you have to two
Relevance.
and to three?
Relevance. I can give you basically.
I'm breaking them down in kind of by sort of category. So
Yes, ma'am.
those are a little bit different from the tax form. So let's now move to the tax forms, which, as I understand it, relate to the offer of exhibits 4 through 17. What objection?
Object to exhibits 4 through 17 on the basis of relevance.
Okay. All right. Mr. Gwynn, the relevance objection suggests that none of these documents are related to the matter before the court.
Next, Mr. Gwynn takes the stand and begins presenting his own evidence. As a third-party observer, this portion feels like an attempt to redirect the entire case. He introduces a promissory note, hearing notices, and additional filings while the judge carefully tries to identify and organize each exhibit. The courtroom slows down as everyone works through the documents, with the central question becoming whether any of them actually support his defense.
Today, I'll give you very briefly an opportunity to why they might be relevant to whether or not the suspension of commitment should be given effect today.
My
Documents have to do with this case.
My IRS agent would like to keep all of us in compliance, and I need all those documents. Anything that I spend, put out, or am billed for, I need to have for my IRS agent.
Okay. All right. Very good. That's very helpful. 17, but please know, Mr. Gwynn, that for purposes of the appellate record, all exhibits that are offered, whether admitted or not, will become part of the case record and available for the appellate court review. So we'll continue to keep them in our records. They'll just not be considered for purposes of the hearing today. Now, Mr. Gwynn, your opportunity next is for you to offer some additional testimony. And because you're representing yourself, it would be silly to ask you to ask yourself a question and then answer it. So I will let you testify in what we call the narrative form. However, if you hear me interrupt you, or if you hear Mr. Powers interrupt by saying the word objection, then I need you to stop your testimony until I've had a chance to deal with the objection that he raises, or if I need to interrupt you for various reasons, I will let you know. But so now, though, it's your opportunity to tell me whatever evidence you want to offer by way of testimony with regard to just the matter before the court, which is whether or not your suspension of the jail order that Judge Mangrum entered should be given effect or not, and should I send you to jail or not, and whether or not I should suspend that order further by ordering that you can stay out of jail by paying some amount of money. It could be some amount you pick, or some amount that if you wish to react to the number that Mr. Powers gave, you can do that as well. I'm ready now for your testimony just on those relevant matters pertaining to the hearing today and none other.
Okay. Thank you, Your Honor. Your Honor, first off, I object to representing myself as a person. I'm actually representing the corporate Jonathan Daniel Gwynn name is who I'm representing, not me as a person. I'm representing the all caps name.
You cannot represent it as corporations by Texas law, must be represented by licensed attorneys. You've told me you're not a licensed attorney, so you're not allowed to represent anybody other than yourself, and you certainly may not be allowed to represent a corporate entity. We'll move on.
I do not represent myself, Your Honor. I do not represent.
Well, let's move on. I understand. Let's move on. What else? I'm asking you to provide whatever additional testimony you wish to provide at this time.
Your Honor, I would like to know if you're standing on your oath today.
I would like to know if you have any additional testimony you wish to provide, because you're on the witness stand. It's your opportunity to give testimony. It is not your opportunity to ask questions. This is your opportunity to tell me your side of the story. And I want to hear it. So tell me your side of the story.
I just want to know if you're standing on your oath today, Your Honor.
I
That's
am
all.
not going to respond to questions because it would be inappropriate for me to do so in that way, at least to that question. I want to know if you have any additional testimony. If you do, I want to hear it. If you don't, we will move on.
I'm sorry, Your Honor. I do have other questions, but I just need to know if you're standing on your oath today. That's all I'm asking.
Mr. Gwynn, you will pass yourself as a witness unless in the next 30 seconds you provide testimony. If you do not provide testimony in the next 30 seconds, I will consider that you have no testimony on this matter to offer. So your choice, sir, provide testimony since you're now on the witness stand, or stand down from the witness stand. Your choice. You have testimony to provide or you don't. If you do, you need to give it to me now.
Okay, Your Honor, I just asked the question. I accept that you're not standing on your oath today, I guess. I don't know what to say because I just wanted to know.
All right, Mr. Powers, do you have any questions for Mr. Gwynn? Because he has passed himself as a witness by virtue of the fact that he has violated my direct order to provide testimony since he's been sworn in and is now providing testimony as a witness. You may ask him any questions if you like.
No, ma'am. I have
All
no
right.
questions for Mr.
That
Gwynn.
will conclude the evidence portion of our proceeding this morning. Mr. Powers, you may make a brief closing argument.
I believe the record is abundantly clear. Mr. Gwynn appeared in court through counsel. He agreed to the imposition of the sentence we're asking you to.
I did not agree. It's an objection.
He agreed on the record.
I did not agree.
Excuse me, Mr. Gwynn, I have noted several times.
You did effing too. You agreed to have it in writing. I mean, it doesn't really matter. Nobody cares. But how do you say that with a straight face?
Times that Judge Mangram's docket notation indicates that you did in fact agree. It's okay if you disagree with that. You can tell me about your disagreement to that when it is your turn to make your closing argument. Right now, it's Mr. Powers' turn to make his closing argument. I ask you, please, to be patient until it is your turn to speak again. Mr. Powers, you may proceed.
So it's abundantly clear that he was ordered to comply with a payment schedule. It is abundantly clear that he has failed to comply with the payment schedule. What I think is particularly appalling is that Mr. Gwynn submitted false documents that were intended to represent that payments were made when they in fact were not. This has been a very difficult case. Mr. Gwynn has historically projected gobbledygook legalistic arguments which have no merit and which are in fact dilatory, time-consuming, and costly for my client to respond to. Accordingly, it's time that Mr. Gwynn suffered the consequences of his failure to comply with the court's order.
Pretty cool.
And we're asking that the relief we requested at the beginning of the hearing be imposed upon Mr. Gwynn at this time.
All right. Thank you, Mr. Powers. Mr. Gwynn, it's now your opportunity to make your closing argument that might be relevant to the issues before the court this morning. If you wish to do so, you may do so. Let me warn you, sir, if you do not stick to the rules and make a closing argument that is relevant to the proceedings, I will interrupt you and then I'll issue my order. So please, just please make a relevant argument to the matters before the court this morning and none other. You may proceed.
Your Honor, I do not consent to jail. I do not consent to jail. I do not consent to jail. I consent to a judge not answer about on oath. I do not consent to the judge standing not stand. I do not consent to not being in compliance with the IRS. I do not consent to not being in compliance with the IRS. I do not consent to further hearings. I do not consent to further hearings. I do not consent to the renting of my son. I do not consent to the renting of my son. I do not consent to the renting of my son. I will say that again because that is my blood-born son, and they have stolen him from me, and that's unconstitutional. And I also do not consent representing myself. I do not consent to representing myself. Do not consent to representing myself, Your Honor. And I have filed paperwork that is constitutional paperwork that Mr. Powers is calling Google, Goggle, whatever, GOP. And there is judicial stamps on my paperwork over the past 12 months that I have filed over and over again, and they just get ignored and completely ignored. And they are on the record, they are on file, and they completely get ignored. And I use
I can't hear you, Mr.
I want a stay of court pending. I want a stay of court pending a United States tax court.
Anything else by way of closing argument, sir?
I want a stay of court pending the United States tax court.
Anything else by way of closing argument that's relevant to the issues?
I want a stay of court pending United States
Yes, you've
tax
said that 3 times, sir. Is there anything else?
I just do not consent to go to jail, Your Honor. I've already shown.
The focus now turns to the admissibility of the exhibits. One after another, objections are raised over relevance. From an outside perspective, this becomes a critical turning point because much of Mr. Gwyn's defense depends on documents the court may never consider. The judge listens to his explanations but repeatedly returns to the same issue, whether the evidence directly addresses the suspended commitment and the alleged failure to comply with prior court orders.
Do this, and I want to say it one more time because, you know, I know you turned down my Turner hearing. I have a promissory note. Promissory note is constitutional. It's in law. Even my IRS agent said I could use it. And I've been wrongfully accused here over years. I haven't seen my son since he was 4 years old. I raised him daily. And Mr. Powers managed to take him away from me and caused so much hardship in my life over this. And I have been wrongfully accused of being a bad father when I'm a great father. And you can see it on my internet. You can see it on my social media, how great a father I am to my current 10-year-old. And I wasn't able to father my child because this man has robbed me of that. This court has robbed me of that. And it is completely unconstitutional that I have done this. And full constitutional principles and protection that was articulated by the U.S. Supreme Court, Turner, you know, and I incorporate by reference all orders of this courts are fully submitted pursuant to Judicial Notice Section 201. The rules require a scalpel, not a butcher knife. And this court ordinarily must apply it to each segment of an affidavit. And none of my affidavits have been responded to, not one. And I have submitted probably over 50 affidavits, and they've all been stamped by the judicial clerk. And not one has been responded to by a judge, Your Honor. Not one. And that is unlawful and unconstitutional. And now I'm asking a judge, Your Honor, with all due respect, and I'm here in front of a judge asking if you're standing on your oath, and I can't even get an answer there.
All right.
And I accept.
Thank you, Mr. Gwynn. Is there anything else?
And I accept that and default of this hearing.
Anything else?
Brought upon the court, by the court, Your Honor.
Okay. Anything else?
I can go on and on, Your Honor, but I just want to get rid of this. And
okay. All right. Thank you, Mr. Gwynn. Normally, I would allow the movement to have the last word because he gets to rebut, but I don't think that's necessary here, Mr. Powers, because I think you've made your position clear on behalf of your client with regard to the relief you request. The relief is granted. Mr. Gwynn, what I want to remind you about is a couple of things. One, when you were here the first time I met you in October, you told me that you were turning your life around and that you were going to do the right thing and pay the amount of money that you owed. And you told me that because you were in that rehab facility, that you needed time to get out of there and get some money together. And I believed you, and I gave you that opportunity. But you didn't keep your end of the bargain in that regard. You showed up later that same morning behind the wheel of a vehicle. So you may not own one, but you clearly have access to one because you were driving a vehicle on Zoom when I asked you to pull over, right? Because
on the property.
And excuse me, I also pointed out that you had changed your clothes. You were nicely dressed at the first part of our hearing. You were more casually dressed later in the day when you were driving. And I questioned whether or not you were really at a rehab facility. But
that is not the issue here.
Excuse me, Mr. Gwynn, it's my turn. And but my point there is that I believed you nonetheless. I believed that you wanted time. I believed that you needed time. I believed that you were going to do your best, having come out of that rehab facility that you were excited about being in and graduating from. And I believe that if given an opportunity, you would do the right thing and come up with the money you said you were going to come up with. And excuse me, sir, I am not done.
I'm asking for forgiveness because
I'm asking you to just be quiet while I finish my statement. I believed you on October 6th, and I gave you a chance to do the right thing, and you didn't do it. And then on October 21st, I gave you another chance because on that day you made me another promise, and yet you haven't kept that one either. On October 21st, you gave me a promise. You said, I'm going to pay these people this $5,000, and I'm going to pay them another $20. Mr. Gwynn, it's not your turn. And I'm going to give some more money later, and I'm going to make good on my promise, Judge. So please postpone this hearing one more time.
I did with a promissory note.
Make a promise to you that I'm going to keep. So October 6th, you made me a promise you didn't keep. October 21st, you made me a promise you didn't keep. And now here on November 9th,
Your Honor, I paid it.
Mr. Gwynn, if you don't stop talking, I'm going to ask my staff to mute your microphone. It is not your turn. I gave you an opportunity to tell me something relevant about this hearing, and you did, and you talked, and I kept asking you if there was anything else. And then when you stopped, I started. It is now your opportunity to be as respectful to me as I have been to you. So I would beg you, please stop talking when I'm talking. So to summarize, I gave you a chance on October 6th. You gave me a promise you didn't keep. I gave you another chance on October 21st. You made me yet another promise, which you did not keep. Not only did you not keep the promise, the funds you pledged turned out to be bogus, and they didn't clear the bank. So that's problematic from my perspective, that you've been given chance after chance. You made promise after promise. You squandered the chances, and you broke the promises. I think we're at the end of our ability to be gracious to you anymore. I think now you have to show some grace and pay your debt. And you will begin by paying, or you will go to jail. And so the order is as follows. The motion is granted. Mr. Powers will be directed to prepare an order today. I want it today so that it can be signed and given effect today and served on all the proper parties and sent to the proper authorities to be effectuated today. The order will reflect not only that the motion is granted, but that Mr. Gwynn is to be remanded to the Travis County Jail. He'll be told in that order where to report. I would imagine it would be downtown at the booking station here that is adjacent to the Travis County Courthouse. It's the Blackwell Thurman Criminal Justice Building. Mr. Gwynn, you will be, and so since I do not want you to report and infect others, and I want you to have an opportunity to heal and get better, I will require that your report date be at 10 a.m. on November 15th instead of today, because I want you to have an opportunity to get better. So you will be required to report to the Travis County Jail at 10 a.m. on November, earlier, but no later than 10 a.m. on November 15th. If you have paid before that date, by the 14th, if you have paid by the 14th of November, the sum of $7,500, you will not have to report. That will not end your obligation. That just means you don't have to report, and the suspended commitment will remain in effect. The review hearings, and you will still be subject to going to jail if you don't further comply. But you will prevent on the 14th if you have paid the sum of $7,500, not pledged it, not written a check that doesn't clear, but actually remitted funds that clear the bank or cash, one or the other, that's valid negotiable tender. And if you do that by the 14th, you don't have to report on the 15th. If you don't do that by close of business on the 14th, you must report on the 15th. Mr. Powers will circulate that order and get it to me today. And that will conclude our business this morning. Apologies to those on the docket who I told we'd only be an hour, because clearly we've gone more than that. Gentlemen, we are adjourned. Take care. Goodbye.
Thank you, Your Honor.
The hearing reaches its climax during closing arguments. As an observer, this is the moment when the judge appears to have made up her mind. Mr. Gwynn asks for another chance and argues against jail, but the court reviews a pattern of missed payments, broken promises, and prior opportunities to comply. After recounting those failures, the judge grants the motion and orders incarceration, while offering one final path to avoid immediate jail through a substantial payment before the deadline. Like the video, subscribe to the channel, and we'll see you in the next video.